How I learned to stop worrying and love software patents. Sorry for the Stanley Kubrick reference, but somehow apocalyptic things get mentioned whenever I start talking about software patents. Now, one task for all of you, there's going to be a question at the end, so shout it out when you see that slide, because I'm not going to be able to see you raising your hand. I'm an IP attorney. Basically, I have 4 tools in my toolbox: trademarks, copyrights, trade secrets, and patents. And my job is to protect my clients. All right, so we're talking about trademarks now. Next. I mean, this is not a tool to be protecting my clients' valuable content. It protects their logos and their names, but it's really not going to help you on the software side, except for the brand. Oh, and trade secrets, WikiLeaks. I should have had the next slide on this one as well. Trade secrets only last so long as they're secret, and in this day and age, it's kind of hard to keep them. Copyrights. Copyrights are useful, except they're only enforceable when somebody actually takes something and copies it. So if you're stealing personnel and people's ideas, it's a little bit difficult. And of course, if we're going to talk about copyrights, we're going to talk about the cute little penguin and actually the wildebeest. GNU, wonderful thing, except it's the most draconian copyright regime known to mankind. They are the most copyright maximalists that we have out there. So what we're left with is patents. And software kind of looks like, well, something that could be patentable. And so the Supreme Court has told us what can be patented. Anything under the sun made by man, as long as it's new, useful, and not obvious. Well, so the thing that we normally think about when we think about something that's patentable is gadgets. And so Kearns invented the intermittent windshield wiper. He made $40 million on that. Hollywood made $3.7 billion on the movie about him. All right, now I'm not talking about business methods here, okay? So how to exercise a cat with a laser, that's not what we're talking about. I'm still worried about business method patents, as are some of you, I think. Software is not business. Software is still technology. And when we talk about software patents, we're talking about innovations in technology, not in innovations in the way people use existing things. And so when we think about the contributions that software brings to our lives, well, the Supreme Court has really given us a lot of guidance here. You can read the slide. Basically, they said, we decide that we're not going to decide. But software is about the brains that we're bringing to our society. And the first software, or the first patent that was issued in the US was about how to make potash. But it's the goal that our Constitution had for providing protection for patents and for inventions was to promote the useful arts, the things that really contribute to our society. And motor vehicles contribute less than 1/3 to our gross domestic product that software and computer consulting does. So you may recognize some of the brands here. I guess trademarks are useful for them. As providing some use in your daily or professional lives. And the skill that goes into those and into the software that's powering these very important devices. I love the fuzzy logic in my rice cooker. It's important. But the amount of software that goes into these devices, most people don't realize. In the new Mercedes-Benz cars, they have over 20 million lines of code that are dedicated just to the dashboard area. But that's leaving aside the intelligence that's involved in the engines. So this person that's on the screen now is what's known as a useful artist. As differentiated from the fine artists, which produce things that we enjoy, these are the useful artists produce things that we use. So one question, somebody shout it out. Any questions? Software patents are not evil. And one of the things that people are so concerned about is how long patents are supposed to prevent other people from using things. Most patents are not extended to their full term, and so At the end of their life, patents are dedicated to the public, and what better way to share these new technological innovations than on a nice patent plaque? Anyhow, rants to here.